are justiciable. 3, if true above is also answered in the affirmative, whether the conservatory orders in place can be lifted. In dealing with the above issues, we remain mindful that we are primarily engaged in a constitutional interpretation process, and that we must stay true to the established principles of interpretation. We have thoroughly examined and rendered ourselves on the appropriate approach to constitutional interpretation in ruling number 1, issued on petition number E522 of 2024, as consolidated with cohort number 1 petitions and hearing after referred to as ruling number 1. We therefore adopt that analysis as part of this ruling by way of reference, as we see no need to rehash the discussion therein. We will now deal with the issues for determination in seriatim.
And I will deal with the first issue, that is whether this court has jurisdiction over the consolidated petitions. The first preliminary issue that was raised before us is the jurisdiction of this bench. While it was also argued that the court has already determined this matter, rendering it res judicata, we believe it is necessary to revisit the issue due to the new arguments that have emerged during submissions and in light of the unprecedented nature of the case before us. We find it prudent to further clarify our jurisdiction so as to ensure that the issue receives the comprehensive and careful consideration that it deserves. In determining this preliminary issue, we are reminded of the authoritative words of Nyarangi J.A. in the widely celebrated case of owners of the motor vessel Lillian S. versus Caltex Oil Kenya Limited, reminding us that without jurisdiction, a court has no power and must down its tools in respect of the matter in question. This principle has since been reaffirmed in numerous landmark decisions by the Supreme Court, underscoring its centrality to the exercise of judicial authority. In the case of Machari and another versus Kenya Commercial Bank Limited, the Supreme Court was unequivocal in its holding that a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court of law can only exercise jurisdiction as conferred by the Constitution or other written law. It is quite a lengthy paragraph there. However, let me also say the Supreme Court stated that where the Constitution exhaustively provides for the jurisdiction of a court of law, the court must operate within the constitutional limits. It cannot expand its jurisdiction through judicial craft or innovation. And the quotation goes on. Likewise, in Adenga and 2 others versus Kibos Distillers Limited and 5 others, the Supreme Court again emphasized as follows: a court, even this court, that is the Supreme Court, cannot arrogate itself jurisdiction through crafts of interpretation, and a court ought to exercise its powers strictly within jurisdictional limits. End of quote. We find it necessary to address the issue of jurisdiction by examining the historical context of Kenya's constitutional drafting process, as highlighted by learned counsel Dr. Thiampolo in his submissions. Counsel presented the court with excerpts from earlier drafts of the Constitution, tracing the evolution that led to the promulgation of the 2010 Constitution. Notably, in all these earlier drafts, express jurisdiction was conferred on the Supreme Court to hear and determine disputes arising from the impeachment process. However, in the final promulgated 2010 Constitution, this specific provision was deliberately omitted. Based on this historical backdrop, Counsel submits that even if this court were to find that this dispute is justiciable, a matter which we will address in the second preliminary issue, jurisdiction should lie with the Supreme Court and not with this court. We have carefully considered this argument, which the petitioners opposed. Article 2.1 of the Constitution is unequivocal that no person or state organ is above the Constitution. It further affirms that all state authority must be exercised in strict conformity with constitutional provisions. By virtue of Article 2.4, any act or omission that violates the Constitution is both unlawful and invalid. This establishes a clear basis on which the actions and omissions of all state organs must be scrutinized for their constitutionality. The bone of contention before us is whether that jurisdiction ought to be exercised by this court or by the Supreme Court. As we have already noted, the final version of the 2010 Constitution marks a clear departure from previous constitutional texts regarding the jurisdiction of the Supreme Court. Specifically, the provision granting the Supreme Court exclusive and original jurisdiction over disputes arising from the impeachment of the President, that bit was deliberately omitted. The Supreme Court's jurisdiction is now strictly redefined under Article 163, Sub-Article 3. This leads us to the firm conclusion that the people of Kenya did not intend to grant such jurisdiction to the Supreme Court. Had that been the intention, the Constitution would have expressly conferred this authority in its final form. The Supreme Court has itself acknowledged that its original jurisdiction as outlined in the Constitution is exhaustive. This implies that any attempt to expand its jurisdiction beyond what is expressly provided for would contradict the Constitution's intent. Again, we refer to the case of Machari and another versus Kenya Commercial Bank, in which the Supreme Court itself stated as such. Article 163 of the Constitution provides for the jurisdiction of the Supreme Court in exhaustive terms, though leaving room for Parliament to prescribe further appellate jurisdiction in terms of Article 163 3B2, which stipulates that the Supreme Court shall have appellate jurisdiction to hear and determine appeals from any other court or tribunal as prescribed by national legislation. The Supreme Court goes on to note that the Constitution also confers jurisdiction upon the Supreme Court to hear and determine an appeal from a judge who has been recommended for removal under Article 168(8). As far as we are aware, Parliament has yet to confer any further appellate jurisdiction upon the Supreme Court in terms of Article 163 3B Roman 2 above. Even with regard to the special jurisdiction previously conferred by Section 14 of the Supreme Court Act, which was repealed by Section 15 of Act number 26 of 2022, the Supreme Court was unequivocal in again affirming that this provision did not grant Parliament the authority to expand the court's jurisdiction beyond what is contemplated in the Constitution. The court expressed this position. Again, we go back to the case of Machari and another versus Kenya Commercial Bank and two others. It's important to read the text. The Supreme Court states as follows: what is the proper province of Article 163(9) of the Constitution? Does the article contemplate a situation where Parliament can confer further jurisdiction upon the Supreme Court? We hold that it doesn't. The act contemplated by Article 163(9) is operational in nature. Such an act was intended to augment the rules made by the Supreme Court for the purpose of regulating the exercise of its jurisdiction. It is an act that must confine itself to the administrative aspects of the court. It is a law that addresses the manner in which the Supreme Court exercises its jurisdiction as conferred by the Constitution or any other legislation. And they go on to summarize, such an act was never intended to create and confer jurisdiction upon the Supreme Court beyond the limits set by the Constitution. From this analysis, we have come to the conclusion that the jurisdiction to hear disputes arising from impeachment of the President and Deputy President does not lie with the Supreme Court within the realm of original and exclusive jurisdiction. Instead, such jurisdiction may be exercisable within the Supreme Court's appellate jurisdiction. We now turn to the jurisdiction conferred on the High Court under Article 165(3) of the Constitution. Notably, the High Court is also vested with a broad scope of original and somewhat residual jurisdiction under Article 165(5), which grants this court jurisdiction over all matters except those explicitly reserved for the Supreme Court or for courts of equal status. This broad jurisdiction demonstrates a deliberate intention by the drafters of the 2010 Constitution to empower the High Court to address matters not expressly covered in the Constitution, ensuring that no legal issues, including, as what is before us, impeachment proceedings, fall outside the court's purview. By vesting the High Court with such extensive authority, the Constitution also guarantees that gaps in constitutional coverage are filled, allowing the court to adjudicate on significant issues that may arise within the evolving landscape of governance. Within this framework, the jurisdiction conferred under Article 165(3) extends to adjudicating any alleged infringement of the Bill of Rights and interpreting the Constitution. In this context, Article 165(3)(d) Roman 2 expressly grants the High Court the authority to determine whether any act purporting to have been done under the authority of the Constitution or any law is inconsistent with or in contravention of the Constitution. This reinforces the High Court's pivotal role as the guardian of constitutional integrity, ensuring that all actions by state organs or individuals are in full compliance with constitutional dictates. A closer examination of the Constitution confirms that the drafters expressly intended to exclude the High Court from hearing appeals related to tribunals established under Article 144. Given this explicit exclusion, and against the foregoing discussion, if the drafters had similarly intended to bar the High Court from determining disputes under Article 145, they would have done so with equal clarity. Nothing would have been simpler, in our view, than to expressly exclude such jurisdiction in the same manner. The absence of such an exclusion with respect to Article 145 strongly suggests to us that the drafters intended for the High Court to retain jurisdiction over such impeachment matters. This approach to interpretation, whereby jurisdiction is said to be unlimited in the absence of any explicit limitation, is supported by the Supreme Court in their decision in the case of R versus Karisa Chengo. The Supreme Court noted as follows, we quote, "The limits of this authority are imposed by the statutes, charter or commission under which the court is constituted and may be extended or restricted by like means. We emphasize that if no restriction or limit is imposed, the jurisdiction is said to be unlimited." The quotation goes further, but that is the emphasis statement. It is undisputed that the impeachment of the Deputy President is a constitutional process outlined in Article 145 of the Constitution. The authority to determine whether the merits and procedures of such an impeachment process align with constitutional requirements, therefore falls squarely within the jurisdiction of the High Court as provided for under Article 165(3)(2). The role of the courts in an impeachment process was reiterated by the Supreme Court in the case of Sonko versus Clark County Assembly of Nairobi. That is another quotation that we have reproduced in our ruling when you get to read it. The court went on to state that the impeachment architecture in the Constitution, the law, and the standing orders leaves no doubt that removal of a governor relates to accountability, political governance, and personal responsibility, and not necessarily about criminal responsibility. It follows that insofar as the process of removal of a governor from office is concerned, the court's role is confined to deciding whether the governor's constitutional rights and fundamental freedoms have been breached in the process, and whether the procedures for removal from office have been followed without the court constituting itself into any of the two constitutional organs in whose hands the power to remove is vested. While we acknowledge that this referenced decision pertains to the impeachment of a governor, we maintain that the same constitutional principles apply to the impeachment of a deputy president. And accordingly, we do hereby find and hold that this court has the jurisdiction to sit and determine the matter that is before it.
The second issue is whether the matters raised in the consolidated petitions are justiciable. Ordinarily, an application for conservatory orders concerning the subject matter of a suit is relatively straightforward, as the law in this area is well established. However, the current applications before the court are far from routine. These applications are imbued with political maneuvering between the applicants and the respondents. In essence, power struggles involving other constitutional organs have been brought before this court for a legal solution. As a result, this court has become the stage upon which political excesses are to be examined and resolved. Inevitably, such cases evoke intense emotions. The impeachment case of the first petitioner currently before this court exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implications for the doctrine of separation of powers among the three arms of government. Answering this issue requires a brief analysis of the doctrine of separation of powers in relation to the doctrine of justiciability. French political philosopher Montesquieu first formulated the doctrine of separation of powers through his seminal work, L'Esprit de Louis, in other words called The Spirit of Laws, which was published in 1748. Montesquieu argued that such separation limits the possibility of arbitrary excesses by the government, since the sanction of all three branches is required for the making, executing, and administering of laws. The Constitution of Kenya 2010 clearly delineates the three arms of government, each with its own distinct personnel and roles, as set out under chapters 8, 9, and 10. Chapter 8 establishes the legislature and details its composition, functions, and powers as the law-making body of the government. Chapter 9 outlines the structure, the functions of the executive, whose primary role is implementing and enforcing laws and policies. Chapter 10 focuses on the judiciary. It defines the structure of the courts and lays out the judiciary's mandate as the arbiter of disputes and the guardian of the Constitution, tasked with interpreting and applying the law impartially. While the provisions regarding judicial power under Chapter 10 of the Constitution are clearly defined, the political question doctrine, also referred to as the non-justiciability doctrine, highlights the limitations on the judiciary's role in adjudicating matters that fall within the purview of other branches of government. This doctrine essentially asserts that certain issues are not suitable for judicial determination because they are better addressed by the legislative or executive branches, which have the constitutional mandate and expertise to handle them. Black's Law Dictionary, 10th edition, at page 943 to page 944, defines justiciability as a matter that is, in quote, proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision, close quote. There is an abundance of judicial pronouncements expounding on the doctrine of the political question. For instance, in Marbury versus Madison, Chief Justice John Marshall established the principle that while the courts have the authority to interpret the law, certain political questions are outside the scope of judicial review. The case underscores that where the Constitution assigns duties to other branches of government and does not provide standards for the judiciary to assess those duties, the matter is deemed as non-justiciable. Closer home, in William Odhiambo Ramogi and two others, versus Attorney General, a five-judge bench observed as follows. The justiciability doctrine is rooted in both constitutional and prudential considerations and evinces respect for the separation of powers, including a properly limited role of the courts in a democratic society. One justiciability concept is the political question doctrine, according to which courts should not adjudicate certain controversies because their resolution is more proper within the political branches. In Baker versus Carr, the United States Supreme Court outlined 6 matters that could present political questions as follows. 1, a textually demonstrable constitutional commitment of the issue to a coordinate political department, or 2, a lack of judicially discoverable and manageable standards for resolving it, and 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. 4, the impossibility of a court's understanding undertaking independent resolution without expressing lack of the respect due to coordinate branches of government, and finally, an unusual need for questioning adherence to a political decision already made and the potentially of embarrassment from multifarious pronouncements by various departments on one issue. Additionally, the Court of Appeal in Kenya Airports Authority versus Mitubel had this to say: with this in mind, the role of the legislature is to make laws and policy, and that of the executive is to implement those laws and policies. The role of the judiciary is to interpret the policies and laws as enacted and approved by the legislature and the executive. Generally, courts have no role to play in policy formulations. Formulation of government policy is a function best suited for the executive and legislature, close quote. In Kiriro versus Ngugi, a 3-judge bench had this to say: a court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of 3 doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. The doctrines are cross-cutting and closely intertwined. We shall, however, endeavor to, as far as possible, delimit the operation of each doctrine in isolation. Close quote. This bench starts with determining whether the issue of the impeachment of the deputy president falls within the category of cases where the concept of non-justiciability would prevent this court from hearing and deciding the matter. The essence of this question lies in assessing whether the political question doctrine would apply, thereby barring the court from intervening in what might be considered a matter reserved for legislative or executive branches under the Constitution. Learned counsel Dr. Thiankolu relied on the U.S. decision in Nixon versus United States to argue the case that the dispute before the court is a political question and hence non-justiciable. We have given due consideration to this decision, noting that it pertained to a dispute involving the impeachment of a Chief Justice of a federal district court in the United States. In resolving the matter, the district court held that it lacked jurisdiction to hear an appeal from the Senate regarding the impeachment of the Chief Judge, deeming the claim non-justiciable. In determining whether a dispute is non-justiciable, the court held that the test depends on whether, in quote, there is a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. The question to ask, in simple terms, is whether the 2010 Constitution specifically assigns the sole responsibility for resolving disputes arising from the impeachment of the Deputy President, as in our case, to another branch of government. Additionally, are there clear legal rules or standards that a court can apply to reach a fair and just decision on such matters? Within the context of the American system, and as articulated by the court, the learned judges answered the first question in the affirmative. They held that Article 1, Section 3, Clause 6 of the U.S. Constitution demonstrates a clear textual commitment of the impeachment process to the Senate. For clarity, this clause, known as the impeachment trial clause, states, in quote, the Senate shall have the sole power to try all impeachments. Close quote. We previously referenced the pre-2010 Constitution drafts that were brought to our attention by Dr. Thiankolu. What is evident from this text is that the people of Kenya clearly intended for the impeachment process to be a justiciable matter. This conclusion is supported by the fact that each constitutional draft contained provisions affirming this intent. This position is unsurprising when considering the historical context in which the Constitution was created. The people of Kenya sought to move beyond a past where the judiciary was often marginalized or bypassed in efforts to check governmental excesses. Instead, they envisioned a new constitutional order in which all branches of government would be held accountable and subject to comprehensive constitutional oversight. This aspiration was central to establishing a balanced system that ensured no arm of government operated beyond scrutiny. We are therefore not convinced, against a holistic reading of our Constitution, that there was any intention to deliberately place the impeachment power on the legislature with no judicial involvement. To hold otherwise would be to create an absurdity whereby the dictates of the Constitution under Articles 23, 160, and 165, 3D2 would be defeated. In our view, this decision is further distinguishable by the fact that the appointment of judges in the United States and Kenya differs significantly due to unique political structures and systems of government. Judicial appointments in the U.S. are more overtly political, with the President and Senate playing direct roles. In contrast, Kenya's system emphasizes judicial oversight through the Judicial Service Commission, which is designed to limit political influence and promote greater judicial independence. Going back to the question that we posed previously, it is clear that unlike the US position, there is no textually demonstrable constitutional commitment of the issue of impeachment solely to any political department or institution. Drawing analogies, the fact that the American context states that the Senate sits to solely try impeachment disputes is a major departure from the 2010 Constitution. Even though the requirements for the two-thirds vote and the taking of an oath are identical, the procedure and provisions of the Constitution, as we have spelled out, leave no doubt that the Senate is not the sole determinant of the dispute. We have already expressed ourselves succinctly on the jurisdiction that has been conferred